Okay, is everybody seeing our great big logo right now?
Yes.
Okay, cool. All right. So thanks so much to Paul and Ree for having us today. This is something Ree and I've been talking about for a while, some of the things you guys are struggling with and ways of trying to address them. For those of you who don't know me, I'm Lance Stewart. I'm a partner with Angius and Terry. We're a law firm. We represent HOAs throughout California, as well as Florida and Ohio, and that's all we've been doing for 35 years. Let's see if I can actually manipulate the... There we go. There's some quick information about our office. This is not itself legal advice, the presentation. This is meant to be for general informational purposes. If you have one of our current clients with an issue that needs addressed, of course, we're happy to help out. If you have an HOA that needs assistance with these issues as they relate to you, we're happy to help out there as well. We don't want, because laws change all the time, we don't want folks relying on outdated information. So we do ask that this not be distributed beyond what Paul and I talked about ahead of time. And I apologize, I'm having trouble juggling my screens right now. And there's the picture of me that I can't stand. Okay, my portion of this is not a mental health presentation at all. I'm absolutely no kind of mental health professional, and except for right now, you're not going to hear me use those words at all. What we're going to focus on is legal tools to try to help you and your team and your boards respond to the community and deal with some of the difficulties that come your way. Something I've certainly found myself saying over and over again over the past couple of years, but really over the past few months, is this feeling that we're experiencing sort of an unprecedented volume of hostile, communications from board members, from homeowners, both in terms of the number of people making demands, the volume of the demands that they're making, and sort of the hostility that's being expressed. I know I feel myself in emotional exhaustion. I feel that I'm not, serving people as well as I usually do, that I'm not serving you guys as well as I usually do. I think the reality is that while a lot of us may be feeling that way and supporting each other is as important as ever, that may not be entirely true. Things may not be entirely, quite as bad as they sometimes feel. So the thing I want to start with is this: things get better. I've been working with HOAs for 7 years. There's certainly people on this call who've been doing it for both much less time and far longer time than I have. Living through a global pandemic can certainly make us all feel like we're living in unprecedented times, that things are much harder than they used to be. But I think we've seen better, we've seen worse, I think we'll see better again. What is true right now is that homeowners are around more. They're working from home. They see more, they notice more, they care more, they're more involved. And they don't really understand how it is they're supposed to communicate with their HOA, or more to the point, how the HOA communicates with them and how it conducts business. So part of our role working together is to try to teach them. So we're going to talk through some scenarios here and see if these things sound familiar at all. You've got a homeowner who's calling you multiple times a day, emailing you multiple times a day, demanding an immediate response. You try to jump on the issue. There's a bunch of back and forth phone calls and emails between your team and the board and that homeowner trying to address the issue. And the harder you pedal, the more there's sort of confusion over what's been said and what's been done. And as all those things are happening, there isn't really so much of a properly noticed board meeting or meeting minutes or any real clear record of what the HOA has done in response to that particular concern. And even after all that hard work has been done and all those steps have been taken, the homeowner is still unhappy and still calling and emailing you multiple times a day. Or what if you've got a scenario where a board member is calling you and emailing you multiple times a day, demanding an immediate response. And you're jumping around, you're talking to the rest of the board, you're talking to your team, you're talking to the board member, trying to give them an immediate response to what they're asking for. And again, there's confusion over what's been said, what's actually been done. And there's no real proper board meeting anywhere in there, or meeting minutes, or documentation of what, except for a flurry of emails and sometimes text messages. No real clear record of what exactly was done, even though you're working tremendously hard to try to address the issue. And at the end of it all, that person is still unhappy and still calling and emailing a bunch of times a day. Or you have a situation with a bunch of people involved. There's the homeowner, there's the vendor, there's multiple vendors, there's multiple board members. You're talking to 3 or 4 or 5 or 10 people 20 times in a day, trying to address the issue, pedaling as fast as you can to get it done. And there's confusion over what's actually going on, even though you're working with everything you have to get it addressed. And there's no proper board meeting, there's no real record of what's been happening, and the issue still isn't resolved at the end of that. And maybe you're feeling a little like this. To try to address these things, let's take it back to basics a little bit. And start with what exactly a homeowners association is. I said at the beginning, and I'll say throughout this, and a lot of you guys have heard me say these things many times before, there's a lot of confusion over what an HOA is and how it's supposed to function. And a lot of that demand for an immediate response comes from that basic misunderstanding. I want an answer right now. Well, that's not how an HOA operates. A homeowners association, and you guys have heard me say this a million times, it's a nonprofit mutual benefit corporation, which means, with limited exceptions, business must be conducted during a properly noticed meeting of the board. Sorry, I'm juggling my screens again. Which usually means that, barring an emergency or some time-sensitive issue, decisions can't be made between board meetings. So once there has been a communication to that homeowner, to whoever it is, acknowledging what they've had to say, I want this, you've acknowledged it, there's usually no real purpose to further communications until that next regular board meeting. And we'll talk about these things in some more detail. Big thing I want to emphasize throughout this is the Open Meeting Act is your friend. It's something we all have to comply with, but it's also a really good tool for prioritizing and triaging the demands that you're receiving from people in the community. So what does that have to say? The board shall not take action on any item of business outside of a board meeting. Anytime there's going to be a board meeting, the HOA has to give notice to the members at least 4 days in advance. If there's going to be an executive session meeting, there has to be notice at least 2 days in advance. The board can't discuss or take action on any item at a non-emergency meeting unless it's on the agenda for that meeting, and the board can't conduct business except during an emergency via emails. You guys have heard me say this before. You take all those things together, and what that means is that nothing can happen, usually, until there's been a notice of a board meeting, at least 4 days in advance, or 2 days for executive session, and there's things on that agenda saying what business the board's going to conduct, and then that gets conducted in that meeting. When we're talking about the idea of emergency board meetings, and I'll talk about what this means for you guys from a practical standpoint in a moment, but an emergency board meeting may be called by the president or any 2 directors other than the president if there are circumstances that could not have been reasonably foreseen, which require immediate attention and possible action by the board, and which of necessity make it impracticable to provide notice to the members. If there is a board meeting that's being held on an emergency basis, you don't need to give notice to members. And that is the one time that they can conduct business during via email if all the board members, each and every board member, unanimously agree to make that decision in writing, to do it over email, and then those email agreements end up being attached to the minutes for the next board meeting. Anytime something gets discussed, an emergency or executive session, it has to be generally noted in the minutes for the following board meeting. These are the things you need to do to make an emergency decision by the board. Other than these things, the board can't conduct a meeting via a series of emails. And from a practical standpoint, the reason all these things matter to the HOA is that if the board doesn't comply with these things, if the HOA doesn't comply with these things, any individual homeowner at any time can bring a lawsuit for violations of those laws and can recover their attorney's fees, court costs, and civil penalties of up to $500 a pop per violation. What's the point? HOA business has to be conducted during a properly noticed meeting of the board. And until there is that meeting, the HOA usually can't provide any response. So you've got a homeowner who's calling you and emailing you and saying, I want this, I want this, I want this. Why haven't I gotten this yet? It's been 2 days. Why haven't I gotten it yet? It's been a week. Why haven't I gotten it yet? What should be happening is the homeowner should be told, and we're going to break this down some more. Okay, I hear you. That's going to go on the agenda for an upcoming meeting. And until that meeting, there's no response I can give you. And the specific wording you use is something you guys determine as part of your team, but that's the overall message. There is nothing for the HOA to do, for you to say, for the board to say, until the board has properly taken that issue up in a properly noticed meeting. That's it. Now, some other factors to be aware of along the way, and this is something for you to discuss with your team leaders, there's a level of decision-making that your company's contract with the HOA envisions you should be able to do on autopilot. There's a level of decision-making that does not require the board's authorization. That's a question for you to be alert to when a homeowner or somebody's making demands of the HOA through you. Is this something that the management team can do on our own? That's something you determine in consultation with your team leaders based on the circumstances. But that's a factor to be aware of. So you've got folks making a lot of demands. These are some basic things to be thinking about in terms of prioritizing those demands. The first one, as I said, is this a request that's within your team's authority to address on your own? Do you need board authorization to do it, or does the contract give you authorization to do it on your own? If you have that authorization, and again, talk to Paul, talk to Ree, talk to your team leaders about whether you have that authorization. But if you do, then you deal with it. And if you don't, then you move on to question number 2, which is this some kind of an emergency? Is there a fire? Is there water gushing into somebody's home? Is there a safety issue? Is there a potential property damage issue if we don't get in there right away? You heard me say this a moment ago. The things that might constitute an emergency are it couldn't have been reasonably foreseen, it needs immediate attention, and it can't wait the 2 to 4 days for a properly noticed board meeting. If it appears to be an emergency, then what you're going to do is request that the board call an emergency meeting. You heard me use this language a moment ago, and it's what most bylaws say. The bylaws will typically spell out who gets to call meetings, but usually it's some variation of the president or any 2 other directors can call a meeting. So formalistically, what's happening is you're saying to the board, I need somebody to call a meeting. I need the president to call a meeting. We have this emergency. I need direction from the board. Dear Mr. President, dear 2 officers, could you please call an emergency meeting of the board so I can get some guidance on this issue? If it's not an emergency, there isn't a fire, there isn't water gushing into somebody's home, there isn't an immediate safety or property damage issue, then you're moving on to question number 3. Is there some other time constraint here, some time sensitivity we need to be thinking about where it can't wait until the next regular board meeting? Document inspection requests are a big one. There's a very specific statute, if you guys don't know already, about responding to homeowners who say they want to see certain HOA records. If it's from the current fiscal year, they're entitled to get that within 10, the HOA has to provide it within 10 business days. If it's the past 2 fiscal years, the HOA has to provide it within 30 calendar days. That's something to be alert to. Is this a request for particular records where we need to get counsel involved to figure out the appropriate response? I need authorization from the board right now. If the homeowner or whoever it is saying, I want a response by this date, that's another factor as well. Maybe it's not an emergency, but this person is demanding action within a certain amount of time, and part of what you're gauging is that a reasonable amount of time? And part of that is going to be the person who's saying, I want a response by Wednesday or I'll sue. It's not an emergency in the sense of being a safety issue or a property damage issue, but it is something that makes it time sensitive for the HOA. You need to get counsel involved and the board involved to determine whether this person is entitled to a response by Wednesday or whatever it is they're saying. So this is sort of the third step in what you're thinking about. Is it something where it's not an emergency, but it's time sensitive? We need to get it addressed right away. Note that for your HOAs that meet quarterly, this is a little bit more complicated. You can't quite push things off to the next meeting so much, because that means folks are waiting, 2-3 months. You need to be alert to whether it's a board that meets quarterly versus monthly. If they meet monthly, then it's easier to sort of go through this process. But the point for right now is, if it's something where there's a time sensitivity to it, it's not an emergency, but it's time sensitive legitimately, can a special, properly noticed meeting of the board be scheduled in an appropriate amount of time? And there again, you're sort of saying to the president or two officers, can somebody please call for a special, properly noticed meeting of the board? We're not going to wait till the next regular meeting, but can we, meet on Thursday? Can we meet early next week? You get your notice posted. There's going to be an executive session meeting in 2 days. There's going to be an open meeting in 4 days. Can we schedule a special meeting? This is time sensitive, but it's not an emergency. We just need to address it promptly. Remember that the notice period for proper meetings isn't all that long, if you can get everybody lined up to just hold the meeting and make a decision. But these are sort of the initial things you're thinking about when somebody is hounding you and hammering you. I need this, I need this, I need this. These are the ways of triaging. Is it something management can address on our own? If not, is it a true emergency? If not, is it something that's time sensitive, where we need to try to schedule a special but properly noticed meeting of the board so we can get a prompt response to this person? If none of those things are true, maybe this person is fired up, but there's not really any obvious time constraint. There's not an emergency. It's just that they're demanding a response. Then what you're going to be doing is put it on the agenda for the next regular meeting. That's entirely appropriate. That's what the law envisions. Not that, we're going to get this to you right away because you want it right away, but that the HOA has to go through its process. The HOA has to go through several steps in order to make a decision about your issue and get you an answer on that issue. So you're putting it on the agenda for the next meeting. And if you're not sure whether that's appropriate, it's okay to ask the board. That's an email communication that's fine. You're allowed to say, guys, this issue has come up. Do any of you want to see this on the agenda for the next meeting? And if any one board member says, yes, I'd like to see that on the agenda, I think we should talk about that, then it goes on the agenda. But that's your default position. If something is not an emergency, it's not time sensitive, then you're putting it on the agenda for the next regular meeting. And you tell the homeowner some version of that. Thanks very much. We heard you. This is going to be taken up by the board in an upcoming meeting. And following that meeting, when the board has had an opportunity to consider it and make an appropriate decision, the HOA will provide a response. I would recommend not necessarily saying the day after the meeting, because sometimes we guys need time to actually act on the board's instruction, but generally convey the message. The HOA has to go through a process. There's going to be a meeting where this is on the agenda. The board will make a decision, and following that meeting, you'll hear back from the HOA. You put the materials in the packet for that board meeting, like you always do. You hold the board meeting. At least a quorum of the board shows up, and a majority of those present decide what the HOA's response to that homeowner is going to be. And that should be the standard operating procedure for everybody that's making a demand. Unless there's a bona fide emergency or other time sensitivity, everything should be some version of this. Thanks very much. We heard you. It's going on the agenda, and we'll follow up with you after that meeting. And then when the meeting happens and you've got your instructions from the board, you provide that response to that homeowner as has been authorized by the board. And the point with all this is it should give you just simple compliance with what the law asks of us all, requires of us all. Should give you a way of properly triaging and prioritizing. I hear all the time, and I deal with it too, managers who are buried in folks saying, I need this right away, I need it right away, I need it right away. And I have to remind myself, the fact that they want it right away doesn't mean they're necessarily entitled to it right away. You appear responsive by saying, thanks very much, we heard you, and here is the process for the HOA giving you a response. Again, barring a bona fide emergency or something else that makes it time sensitive. And that hopefully culls away some of the onslaught we feel sometimes of, 15 people are hounding me with all these different things and they all want an answer right away. This is an appropriate and frankly legally required way of saying, thanks very much, please wait your turn. Some other tools to be thinking about. Everything I just talked about, most homeowners, most board members don't really know. They don't know any of this. Sorry, I'm looking back through my notes here. Homeowners don't understand how an HOA functions. Board members don't understand how an HOA functions. They don't understand that their community is a corporation. That doesn't make any sense. We live in a neighborhood where people in homes, how could it be a corporation? Well, it is. They certainly don't understand how one is supposed to operate. They think, and understandably so, that when they have an issue, then there's one person who needs to deal with that issue. They have no clue about the basic idea that most HOA decisions must be routed through several steps before the HOA, the corporation, can actually give them an answer. Board trainings. And this isn't meant to be a shameless plug, but we of course provide board trainings. You guys hear about them all the time. 1 hour legal presentation explaining to the boards all these things. How is the HOA supposed to be conducting business? The Open Meeting Act, management's role, things along those lines. This is the way the HOA is supposed to be functioning. And homeowner trainings. Please help me get out the word on homeowner trainings. We do them and they can be very effective, but we talk about it all the time and I feel like nobody takes me up on it. We provide homeowner trainings, a presentation that is open to all the homeowners in the community explaining these things. The HOA is a corporation. The Open Meeting Act works this way. Here's how management is involved. Everything they need for the light to finally go on and for them to understand how they're supposed to interact with the HOA and what they can reasonably expect from the board, from you. Anybody wants a proposal, I'm happy to give one. But it ends up falling on us and on you guys to hold people to this basic idea that the HOA can't give you an answer until there's a properly noticed meeting. I was talking with somebody recently who made the point that what makes people good community managers is you want to help people. That's why you're good at what you do. You're good people and you want to help people. So your natural impulse when someone makes a lot of demands of you is to want to get them what they need. And I'm sure there's lots of, that's what's expected of you in terms of job performance, and that's great. But just remember that if you need the board's approval to do something, the law requires that the board make that decision during a properly noticed meeting. That's not you failing to be unresponsive. That's not the board failing to be responsive. That's what the law requires of all of this. And it sort of ends up falling to us and to you guys to put that message out there. Thanks very much. We heard you. And your place in line is here. And here's when you can reasonably expect a response from the HOA. And thanks so much for your patience. But providing board trainings, providing homeowner trainings, I think are critical to making sure folks understand how these things are supposed to work. If they don't understand all these things I'm talking about, then they're going to keep making these demands of all of us. Okay, that brings us to actual harassing conduct. And it's a fine line sometimes. Is someone being demanding, but justifiably so? Or are they being abusive? I was saying again just the other day, I feel a lot of the time like there's this person over here who has a legitimate issue that needs attended to, but there's this person over here who's being really noisy and threatening to go to court tomorrow. So who gets my attention? Well, unfortunately, sometimes it's this person over here rather than the person who really needs it. We have to remember to focus on the people who need the help the HOA actually can provide the most, not just the people who are noisiest. But the point for right now is that the fact that someone is being demanding doesn't necessarily make it abuse. They may have a legitimate issue. You want to work with counsel, work with the board on making that determination. But things that might make it abuse, there's some easy things. Foul language. I'm perfectly fine with saying that's never appropriate. Yelling. I'm perfectly fine with saying that's never appropriate. Even being disrespectful, you're bad at your job, Collins is bad at what they do, the board is corrupt, whatever else. I'm fine with arguing that those things are inappropriate. Your role ends up being to bring it to the board's attention and recommend counsel get involved to help make that determination. But potentially what we're talking about, if somebody is treating you in an abusive way, is an enforcement issue. under the governing documents. Even if that HOA doesn't have specific policies in place, we or their counsel can generally argue that it falls under some portion of the CC&Rs. Usually we're talking about the nuisance prohibition. So you encourage the board to work with counsel to explore a courtesy warning letter, a disciplinary hearing, depending how bad it is, maybe IDR, maybe ADR, maybe all the way up to litigation. And we will certainly make the point to the board that this is something the HOA needs to take seriously, not just because it's, you know, hard on you, but certainly we've seen vendors, not just management companies, walk because of the abuse of one homeowner. And that's not good for anyone. It can help if the HOA has appropriate policies in place. A nuisance or harassment policy can be very helpful if the CC&Rs are vague, where it's not really clear that there's, you know, you can't abuse your community manager. If that's not really spelled out in the CC&Rs, a nuisance and harassment policy can be good for giving that some teeth, so the board has some actual things they can do to address the matter in a proper disciplinary hearing with that individual. So some sample language we might put in a policy is no person and or entity may engage in any abusive or harassing behavior or any form of intimidation or aggression, whether verbal or physical, against another person and or entity inside the community. So if somebody is yelling and screaming at you guys over the phone and using foul language and everything else, certainly that can be pursued as an enforcement issue under the governing documents, particularly if a policy like this is in place. And if we're talking about issues with individual board members, I'm sure I've done codes of conduct for a lot of you guys. A board code of conduct can help give some grounding to that concern as well. We might use language like this: directors, meaning the board members, and community members are prohibited from harassing or threatening employees, vendors, meaning you guys, other directors, other community members, and owners, whether verbally, physically, or otherwise. And again, the point is that the HOA has an enforcement process, a disciplinary process to address abusive conduct. It helps if they have policies like this in place to give some teeth to whatever language is in the CC&Rs, but usually there's some way of treating it as an enforcement issue to get that person to stop doing what they're doing. And that brings us to the issue of what about when it's the board member? Now, from a purely procedural standpoint, this is a little bit more complicated. What do you do when a board member is giving you a hard time? The HOA needs to authorize council or us to get involved, and that usually means getting proper approval from the rest of the board without that person necessarily present. For you guys, the issue is you know, getting us involved, getting council involved as quickly as you can. Feel free to reach out to me or reach out to somebody in our office to say, you know, I'm getting abused by this director. I'm not sure what to do. Can you provide some sort of proposal or recommendation? And we'll take it from there. But usually what we're doing is saying some version of, okay, I need to meet with the rest of the board. I need to separately communicate to that director. I do this all the time. The board is going to be having a meeting to talk about concerns regarding your conduct. You are going to be recused from that meeting. But rest assured, if the board is considering taking some action against you, you will have a full opportunity to be heard before that happens. And what I'm outlining for them is, one, you're not invited to this meeting, but it may lead to a disciplinary hearing. Nothing bad is going to happen to you until you have that hearing. So don't get nervous about the fact that the board is going to be talking about you behind your back. They have to go through that step. We have to do a properly noticed meeting, and I'm giving you a heads up, you're not going to be invited to that meeting, so you don't wonder what's going on. But we have it properly documented that the HOA went through those steps. And if the board determines to call that person to a hearing, then we give them notice of a hearing and we address the issue then. And that's when they have their chance to say, wait a second, this is crazy. I can't believe you've accused me of this, blah, blah, blah. But there's a number of things that we can help the non-recused board do to address the issue. It might take the form of a warning letter. I'm a big fan of the big, long, scary attorney letter outlining chapter and verse on that board member's fiduciary duties, their obligations under the law, the potential repercussions for them and the HOA if they continue in this fashion, the specific things that are going on, and what needs to stop. And sometimes a letter that looks like that is enough to stop the issue. Sometimes we need to go to a disciplinary hearing, and the board at that point is entitled to consider certain forms of sanctions specific to the fact that this person is a director. They can strip them of their office. You're the vice president. Well, guess what? Not anymore. The rest of the board is determined to stop you from holding that particular office. You're on the architectural committee. Well, guess what? Not anymore. We are stripping you of that role. The board can demand their resignation. They can do what's called private censure, meaning there's a record in the HOA's documents, but it's not broadcast to the community. You can do formal condemnation to the community, although that brings some potential risks with it. And you can pursue, the board can pursue litigation against that individual. There are, of course, limitations on what the board can actually do. The board cannot kick one of its own off the board. The board can't, by majority vote, say, okay, you know, Bill, you're not on the board anymore. Only the membership can hold a membership vote doing that. But we've found these steps to be particularly effective. Diana Byrne and I had one not long ago, Diana, I see you're online, where the board was extremely upset about the conduct of one board member. It was driving them crazy, and the feeling was this was a guy who sort of made people miserable until they resigned from the board and then filled the seats with folks that he liked, and he did it over and over again and had been there forever, and there was no stopping him. And we outlined this process for the non-recused board. And they said, Lance, you know, that's going to take too long. That's going to take forever. We want him gone right now. We can't stand anymore. We're going to resign right now. We want him to resign right now. And we said, well, it can't quite work that way, but here are the things you can do. And then nothing really happened for a few months. And they came back and said, Lance, we want him gone right now. We want him to resign right now, or we're all going to resign right now. We talked about the same process and sent him the hearing notice that went through, like I say, chapter and verse, big, long, scary attorney letter, chapter and verse on that person's obligations under the law, fiduciary duty, what they had specifically been doing, the consequences for them in the HOA. And as I recall, the hearing notice went out over email 4:45 on a Friday afternoon. And I think at 5:10, the guy called Diana to give his resignation. Tools like this can be deceptively effective in addressing the types of issues that we all sometimes struggle with. So those are some thoughts on when the board member is the problem. General thoughts, again, the Open Meeting Act is your friend. We all talk about it all the time, but it's a wonderful tool, I think, for prioritizing and triaging when you've got a zillion people calling your name at the same time. As a general matter, if it's not an emergency, it's not time sensitive, it should be going on the agenda for the next regular board meeting. And once the homeowners are told that, there is usually no reason for further communication until that meeting happens. Consider board trainings, please consider homeowner trainings to make sure everybody in the community understands how things are supposed to work and what they can reasonably expect from your office and from the board. And if there is legitimate abuse or harassment going on, get counsel involved for handling, but there's enforcement steps that that the board can take to address that issue, whether it's a homeowner or a sitting director. So those are the points that I wanted to highlight and emphasize. I want to open up to questions, but do we have Craig? Is he available to talk through his piece?
I was able to make it in, so I am present.
Oh, great. Okay, well, I'll shut up then, and Craig, you say what you have to say, because I know you got time constraints, and then we'll.
No worries. I have a few minutes, so if you do have a few questions, I'm happy to hold off for a few minutes.
Anybody
I had a question,
Yep.
Lance.
Mm-hmm.
To what extent, because we're kind of building out a policy to deal with things between meetings, and a part of that is utilizing executive committees that are sub quorum. Are you comfortable with adding that to the mix, especially for the quarterly associations, so that some decisions that maybe can wait, but let's get them off the books so that the meetings aren't 3 hours long, and decisions can be made between meetings within the charter of the subcommittee or the executive committee. Are you comfortable with that as a strategy?
Absolutely. That's absolutely one of the tools for getting business handled properly. And you said the magic words. There's a charter, a resolution where everyone is clear, and council has drafted that. Everyone is clear on what authority that committee has and the limitations of that authority. Is it an advisory committee, or do they actually have decision-making power? If there are a quorum of the board on the committee, then the Open Meeting Act applies, and we have to give the same notice of those meetings. If it's not that, you still want to be careful with what you're doing. And committee meetings, remember, always have to have minutes for what they're doing. But the big stumbling block we see is, and I'm dealing with this right now, confusion over what the authority of the committee is and what business they're actually conducting. But if you have that charter, you have guidance from council on what exactly the committee is doing, what they can do, then yeah, absolutely, that's an appropriate way of conducting business and not having to necessarily wait for every single meeting.
Thank you. Excellent presentation.
Thank you. Thank you.
Thank you so much. As always, Lance. Does anybody have any last minute questions? Or, well, if you have any questions, you know where to find Lance, and appreciate it. Thank you so very much.
Absolutely. Absolutely.
Thanks, Lance. I'll be talking to you soon.
Okay, great. All right. Thanks very much, everyone. Have a good rest of your meeting.
Thank you, Lance.
Bye.
That's great.